It is entirely possible that Prince Harry might be forced to pay a significant sum of MGN's legal costs even though he won the claim. Watch this video to find out why. But first of all, if you're new to me, I'm Daniel Smith, a barrister of England and Wales, and I enjoy helping you to understand law. So I'd be very grateful if you hit that subscribe button and help my channel grow and reach a wider audience. That's how this YouTube thing works. So let's have a look at why, technically, Harry could be forced to pay some or a significant sum of MGN's legal costs. Do I think it's likely? Probably not. And there's a hint as to why I think that in the judgment, but we'll come back to that in a moment. But the general rule for costs in England and Wales is loser pays winner's costs. That's the starting point. There's all sorts of reasons why they might not pay them. There's all sorts of reasons why they might be deducted and everything else. Costs are a significantly difficult area of practice, so much so that many barristers just don't like doing it, and even many judges don't like doing it, so they are better left for those that are comfortable with numbers and all of the cost rules and practicing in that area. But speaking of rules, there is a specific rule in England and Wales in our civil procedure rules known as Part 36, a set of rules governing official offers that have specific cost consequences on parties that should have settled a claim instead of going to court. This is referred to as a Part 36 offer. I'll come back to that in a moment, but offers generally can affect costs. So in other words, court should be a last resort. So if somebody should settle a claim on an offer they receive, and I say should because if the judgment is not more than what the offer is for, then obviously they should have accepted the settlement because court should be a last resort. And therefore it might have cost consequences. Let me give you a very straightforward example. If there is, let's start with a totally unmeritorious, let's call it a ridiculous claim that should never succeed, and one party is being sued, and they look at the papers and they think, this is utterly ridiculous. But just to make it go away, we'll give you £100 or £500 and say, we don't agree with your claim at all, but we'd like to just resolve this and move on, but without opening the floodgates. Clearly, if they offered them £10,000, that might well open floodgates to all sorts of spurious and ridiculous claims. And then you might get all sorts of people coming along for their £10,000. However, in the case where they find it utterly ridiculous and they say, look, we don't agree with the claim, here's £100, please just go away. They might then settle and obviously discontinue the claim. These are referred to as calderbank offers. Now, it doesn't have to be a calderbank offer. It can be any kind of offer. And offers are usually, to use the phrase, without prejudice, which usually means it's done on the trust that it's in private and it shouldn't ordinarily be used in court to prove your principal claim, or defence even. But when you come to costs, then the court will look at that without prejudice communication to determine who should pay whose cost, how much, etc. So in the event that one party has offered, let's say in the region now of £50,000 and said, okay, there might well be a claim here. We don't necessarily agree with it. We're not making any admissions about it, but we'll make you the offer of £50,000. And that will be without prejudice on a private basis to settle the claim outside of court, as the saying goes. If the other party just refuses and doesn't accept that offer and goes to court, and the court then says, well, you have some kind of a claim, but only for £2,000 or £3,000, nothing like the £50,000 they were offered beforehand, then quite obviously they should have accepted the £50,000 offer. At which point the party who made the offer would then say to the court, well, we made this offer of £50,000 X months or years ago. Everything should have stopped at that point, clearly, because the court didn't think it was worth £50,000, only £2,000 or £3,000. And therefore, when deciding costs, it is not fair that either party that made the offer had to continue paying for their legal representation and litigation all the way through to trial, which of course is the most expensive part. When they made an offer right at the beginning or whenever it was, and incidentally, you can make an offer before litigation begins, but I'll come back to that in a moment as well. So it isn't fair that that party pays all of those costs all the way through to trial when they made an offer beforehand. Now, how the court deals with that is the court will look at when that offer was made and whether or not it's fair that the winning party should receive all of those costs from the point forward after that offer was made. So then we come to Part 36 offers. Now, just to be clear, in this Prince Harry and MGN case, I obviously don't have any idea of any private offers that were made, Part 36 or otherwise. I haven't seen any, and that is because the without prejudice basis means that they are private and they will only be disclosed at hearings that are designed to argue over costs, who pays costs and how much they pay. But a Part 36 offer is specific in that there's lots of rules around it without getting into too much detail, but some simple rules are it has to be open for acceptance for a minimum of 21 days. It can be open for longer, but very often it's just limited to 21 days, the minimum amount that it needs to be open for to settle the litigation. The other party, if they accept it, obviously that is it. Then the case is discontinued and the party making the offer makes the payment of whatever it is they've offered. Now, under Part 36, an offer can be made in respect of the whole of a claim, part of a claim, any issue that arises in connection with the claim, and it includes either a claim, a counterclaim, which is simply a claim made against a claim in the opposite direction, or any other additional claim. They also apply to appeals and cross appeals from decisions made at trial. And among other rules, a Part 36 offer must also be made in writing. But let's say in a case where a defendant, such as MGN in this case, makes an offer to a claimant in the case, such as Prince Harry, that is compliant with Part 36 rules, if the claimant in that case does not accept the offer, but does not get a better judgment at trial, even if they win, then that sets in motion various consequences, set out in Part 36, Rule 36.17. And there are separate rules depending on who has made the offer. In the case where a defendant has made the offer, but the claimant didn't accept it, but the claimant does not better that offer at judgment, then the defendant is entitled to all of those costs incurred, including any recoverable pre-action costs, those costs incurred before litigation, from the date that the relevant period, the minimum period of 21 days, expires, and interest on those costs. And there are separate rules about claimants as well. And just very briefly, the other way round, the claimant would be entitled, if the defendant didn't accept an offer made by the claimant, that the claimant would be entitled to costs on the indemnity basis from that same point in time, interest on those costs but not exceeding 10%, and potentially an additional amount on top of that as well. So there it is. Technically, it's possible that Prince Harry or any claimant, even though they win their case, may end up having to pay the legal costs of the defendant in the event that a defendant made an offer that they should have accepted. Now, I say I don't think this is likely, and I say that because there's a hint in the judgment at paragraph 8 where the judge said, unlike in previous years, the 4 sample claims and many others have not settled. MGN explained in case management conferences preceding this trial that it was now unwilling to settle claims because it wanted certain key issues to be decided by the court, which could have a significant effect on the way that other claims will be settled. And essentially, I interpret that to mean they don't want to open the floodgates, because if the court had decided certain things that would preclude lots of other claims, then obviously they wouldn't have to entertain the idea of settling those types of claims. But all this really confirms is that MGN was unwilling to settle claims at the point of a case management conference, sometimes referred to as a CMC. And when it's discussing costs as well, it's a CCMC, a costs and case management conference. It's just a hearing where you go to court to discuss timetabling, costs, and all of these sorts of things, including disclosure and things of that nature. So ultimately, it's quite likely, in my view, that at some point in time, MGN was willing to settle the case and probably made certain offers, maybe even Part 36 offers, that would have had the effect that I've described in this video. We won't know necessarily unless and until a judgment is made on costs, which is, I understand, to be in a hearing in around a month from now, I remember reading that somewhere, but I can't find it now. Otherwise, I'd point you to it. I remember reading somewhere that there's another hearing set for costs and other things. So if I hear about that, I'll let you know. And we might find out whether or not he's going to get all of his costs or whether it tips the other way. So I thought you might find that interesting, where a claimant can end up paying the costs of the other side, even if they win a case, because some people have asked that in the comments section. If you do find that vaguely interesting, to adopt the phraseology of my learned friend, Mr. Alan Robertshaw, who I will link in the description below because we co-host another channel together, please do bop that subscribe button, like the video, because that does all those great algorithmic things that YouTube uses to grow my channel. Thank you for watching. I'll see you next time.